so glad you could join me today. I'm here to talk about an interesting topic, which is actually helping victims of sexual assault, because there's been a movement afoot in Canadian law in recent years to get rid of what I call myths and stereotypes in sexual crimes or sexual assault. This is sometimes referred as to rape myths and stereotypes. That's a phrase that's often used. And what does that mean? Well, I think these are misconceptions about how a victim of sexual assault is to react to a situation. There's no place in Canadian law for that. The courts have ruled. That's gone right up the Supreme Court of Canada. There was a case called Barton that went right up to the high levels of court, and it set the tone, and the Supreme Court of Canada set the tone to say, well, no, there's no place for myths and stereotypes in Canadian law. We have to caution judges and juries against this. So let me give you an example. So maybe a lot of people intuitively might think, well, how should a victim of a rape or sexual assault act? They should say, oh, they should strongly resist and say no and fight back and yell. Well, no, that's not necessarily the case. Studies have shown that that's not the case at all. Some people might do that. Everyone reacts differently. Or after the alleged rape, they should be in tears and go cry rape to everyone around. No, a lot of people will go into a shell or not say anything, or even act differently after it. Or they should report it to the police right away. Well, some victims don't report for years, as an example. So it's, there's demeanor issues, the way a person should appear during the rape or after. This has no bearing in a Canadian court. Studies have shown that everyone reacts differently. Hey, maybe a majority of people are going to be yelling, who knows, but a lot aren't, and the studies have consistently shown. So the Supreme Court of Canada has cautioned judges that these myths have no place in a Canadian courtroom. So as defense counsel, I got to be very careful when I cross-examine, because if it's not part of the evidence, for example, if the person's not crying an hour later, I can't start cross-examining, you weren't crying, or I can't start cross-examining that you weren't screaming out in the bedroom, there's other people in the next room, why didn't you cry out? So these in past years, defense counsel would, 10, 20, 30 years ago, defense counsel would use all these myths and stereotypes to win cases, and it has no place anymore. So you have to be very cautious. A judge is going to charge the jury. Look, don't come with any preconceived notions or bias here. Every victim reacts differently. And if it came out in evidence that the person wasn't crying later, they've got to caution the jury. Well, that's not necessarily disproving that they were sexually assaulted if they didn't have a demeanor. And let me give you an example of cases I've seen. So let's say a person's been sexually assaulted, and 20 minutes later, they're in a hot tub with the perpetrator, and they're smiling and laughing and talking and engaging with them. Well, under our law of rape myths and stereotypes, a jury would have to be told that that's not really evidence that it didn't happen. So that's another myth and stereotype that studies have shown. So everyone reacts differently. A person could be in shock, et cetera, et cetera. So it's very important. As defense counsel, judges, and Crown counsel, we all have to understand these issues very well and work within the confines of the rules of evidence. And as a defense lawyer, I'm always ultra cautious of these issues and know the law obviously very well, so I don't extend beyond the bounds. Now, there are situations where a victim, though, can open up the door to introducing one of these so-called myths, because it's not a myth anymore. She might say, for example, oh, I was extremely upset 10 minutes later and crying, and yet, for example, I have a video of her doing something opposite. That's a totally different issue. I've had many cases like that where it would have been a myth or stereotype, but the alleged victim opened up the door, and obviously we won the case. They weren't credible for that, and many other reasons. I mean, this has happened to me in several cases over the last several years where they opened the door that I could actually use positive evidence that ordinarily would have been a myth and stereotype. So, judges and jurors, they can't come to court with preconceived notions, and studies back this up. I'm agreeing that these are valid myths and stereotypes that we've been using in past decades irresponsibly and wrongly, and I'm really glad that they cleaned this up in the Canadian court system, because it creates a fairer trial for victims who've been vilified, sexual assault victims, for years. We still have the presumption of innocence and proof beyond a reasonable doubt, and those are fundamental guarantees which are still going to ensure a fair and valid trial. And I'm glad we've got rid of rape myths and stereotypes in our Canadian criminal justice system. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.